You asked me to...
I'm sorry, I understood earlier you said you had an additional...
Yes, on restraint of wills. Now, based on my conversation with Judge Swift and what I understand his position on the previous proposal from 2003 was, the restraint of will is understandable. I think I understand what he means there. So I asked the following question. If having the right to say, this is how things are going to be handled when I change my will is a restraint of will, what about an irrevocable trust? You know, I can give away my property today as an irrevocable trust, and basically I've given it away. Isn't that a restraint of will? Now, one of the things I proposed because of these kinds of concerns is something I call a conditionally irrevocable trust, which is a trust that begins revocable, and then upon the satisfaction of conditions when they become, that you specify, become operable, in other words, when they're satisfied, then the trust becomes irrevocable. So, for example, you might have a trust that says, it's a revocable trust, a living will that many people know by, and it says, well, when I'm placed under morphine and I do not resuscitate order, at that point I want my trust to become irrevocable so that, nobody's going to, I've prevented this kind of abuse. Now, that's a restraint of will, but it's many years down the road before it affects me, and I can change things for a long time, so I have much less restraint of will than an irrevocable trust that I begin today. Why can't I have that? Well, even though we haven't had the conversation on that, basically the gist I've gotten from other members of the legal profession is the same problem, restraint of will, or unconstitutional, supposedly. So I had a conversation, I came across an article by a New York attorney about a year ago. Her name is Celia, and you can find her information on the internet, or I can provide it for you if you contact me. She was advertising what she called a senior trust. Guess what? Senior trust is a conditionally irrevocable trust. It matches almost exactly what I proposed 10 years ago that lawmakers here in Ohio prevent. So I called Celia up.
What is the question for Judge Swift?
So the question is, why isn't it an irrevocable? Why do we allow a restraint of will on it when an irrevocable trust if we can't have these other restraint of wills? Why, if I can just create an irrevocable trust without going before the court, can't I have a restraint of will by going before the court and saying this is how I want things handled?